Hello, everyone, and welcome to this month's webinar, the 2022 Annual Employment Law Update Ask the Attorneys webinar session. This specially formatted free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Blicky, the Corporate Accounts Executive for Personnel Concepts, and I'm joined by my co-moderator, Leon Frierson, who serves as our Senior Regulatory Researcher.
Hello and good afternoon to all of our attendees. Now that we've crossed into 2022, employers have the daunting task of implementing the employment laws that were enacted throughout 2021 and have recently gone into effect on January 1st. Grasping employer requirements in their entirety and properly addressing labor laws through workplace policy is best served with the assistance of experienced legal counsel. So to answer that call, Personnel Concepts has reimagined today's webinar format, allocating the bulk of the 1-hour webinar to a live Q&A session with our panel of expert employment law attorneys.
That's right. So today's agenda will consist of an introduction of each of our attorney guest panelists. At that time, they'll provide us with an overview of the most impactful COVID-19 wage and hour and anti-discrimination employment laws they have observed throughout 2021. Next, our guest panelists will accept questions and answer them live, providing our beloved Personnel Concepts customers with the invaluable experience of engaging with knowledgeable attorneys on the most critical employment laws affecting employers in 2022. Before we leave, we'll provide some key takeaways from today's session, and throughout, we'll be engaging the audience with poll questions.
Yes, and then speaking of engagement, let's get started with the first poll. Today's webinar session is heavily dependent on audience participation. So to make the best use of our time, we're in search of timely and meaningful employment law questions to present to our panel of experts. So to ensure that we will fulfill today's hour with helpful content, we need to know, and we'll go ahead and open the chat here. Do you have any questions prepared for today's 2022 employment law session? So I'll go ahead and launch that. And we'd like to know if you have one or A, submitted a question during the registration process. Is it B? Yes, I do have a question. I will submit it in the GoToWebinar chat feature. Is it C? Yes, I'd like to join the broadcast and ask my question live. That is an opportunity if you use the raise hand feature in GoToWebinar. We'll talk about that in just a bit. Is it D? No, I don't have any questions, but I may ask a question based on the presentation. So maybe you're thinking of one. Or is it E? No, I don't need any complimentary employment law advice. Hopefully you came here to get some actual advice. And I see that a number of people have actually submitted questions. A lot of people may develop questions as they listen to the presentation. We'll give just a few more seconds for you guys all to respond. And here are your results. So 81% of you don't have a question at this time. However, you may have a question based on what you see in the presentation. So we'll talk about how to submit those questions throughout. And thank you for everyone that has submitted questions in the registration process. Much appreciated.
Yeah, thanks so much. So as your Q&A session moderator, I'll be directing your submitted questions to the guest panelists based on their area of expertise. Keep in mind your questions may be slightly modified to ensure the best outcome for the session. On some topics, you may hear from multiple speakers, allowing us to give you a well-rounded presentation experience. The purpose of this webinar is to provide accurate and authoritative information on the subject matters being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resources professionals on specific matters pertaining to your business. Personnel Concepts, our webinar hosts, and our guest panel are not liable for any errors, omissions, or changes in law or advice that leads to unfavorable outcomes.
And then on today's webinar, we're hosting
Leon,
three.
just switching the phone.
Yep. And then on today's webinar, we're hosting 3 special guest attorney panelists to deliver guidance on the topic and answer questions in today's Q&A session. All 3 have previously been featured as guest speakers in our webinars. First, I'd like to welcome back attorney Jeffrey, who is a graduate from Vermont Law School and a dual master's degree in JD. It serves as in-house legal counsel to a diverse group of corporate clients. Jeff provides counsel to his business clients on matters including labor disputes, employment negotiations, anti-discrimination, workplace policies, equity agreements, non-disclosure agreements, and general consultation. And then today, Jeff will cover 2022 workplace safety issues stemming from laws and mandates in response to COVID-19.
Okay, thanks for having me, Leon and Stephanie. It's nice to be here today on behalf of Personnel Concepts. Let's begin with addressing one of the biggest issues on the minds of employers today, which is the vaccine mandate. In November, the Occupational Safety and Health Administration, federal agency also known as OSHA, issued its highly anticipated Emergency Temporary Standard, or ETS, mandating that employers with 100 or more employees implement a COVID-19 vaccination or alternatively testing requirement. Originally, employers had until the first week of January 2022 to comply or otherwise face steep fines. Under this standard, such employers must require their employers to be either fully vaccinated or submit to weekly COVID-19 testing and wear a facial covering while in the workplace. This standard applies to workplace safety, however, and does not cover employers that are working remotely or that are independent contractors. Just to clarify, that's fully remotely. So if they haven't come into the office a partial time or on a split schedule. Many of our businesses joining the presentation today are likely to going to have questions related to legal challenges with the ETS standard. The short answer for everyone is that applicability of the standard is going to vary widely depending on where your business is located, either where its center of operations are or perhaps where its plant or facility is. Many of these standards with the vaccine mandates are being challenged right now in the federal courts because they're originating in federal agencies. There's 13 different appellate courts and circuit courts in the United States, 94 different district courts. That's a lot of courts, and they all have different opinions about how to apply this standard that's being challenged by the private sector. So my recommendation that I'll talk about more today is to try to follow the standard as if it were in place, because the federal government is going to continue to try where they can to impose it, to levy steep fines where they can, and the litigation that's presently going on that's percolating through our federal court system could take years to resolve. Additionally, on top of this vaccine mandate, there's also mandates in place related to healthcare workers who are covered through some of the federal funding that goes to hospitals and federally qualified health centers, and also contractors, which is any business that does business under contract with the United States federal government. Today, I'll be prepared to answer your questions regarding these various mandates and other COVID-19 related workplace safety issues.
Thank you so much, Jeffrey. To assist our audience with the wage and hour updates that are of the highest concern to employers in 2022, we have attorney Christopher Ray Esquire. Christopher is barred in the states of Massachusetts and New Hampshire. He has served on both the employer and the employee sides of litigation matters, including litigation before the EEOC. He also provides regulatory compliance guidance for businesses in high-risk verticals such as cryptocurrency and legal adult use cannabis industry, and provides compliance training, ERISA plan design consultation, risk management, and employment law guidance. He received his JD from Suffolk University Law School, graduating with distinction with an elective concentration in labor and employment law.
Great, thank you as always for that warm intro. Always a pleasure to be here with Personnel Concepts. So, as I'm sure you can tell, the principal policy challenge for federal lawmakers, the people most responsible for affecting the employment laws that affect your business, was, of course, reactions in wage and hour law to the COVID-19 pandemic. From the federal perspective, this took many forms, one being the vaccine mandate, others being these enormous temporary expansions of the unemployment system, which created a lot of new legal questions around both the administration of that system and around the obligations of employers to cooperate in the administration of that system. For example, you may have heard that some states, which bear a large amount of the responsibility for actually administering the unemployment system, have varied their definitions of these once very staid concepts like voluntary quit to, for example, extend coverage to employees who voluntarily quit in the face of vaccine mandates. Some states have passed such amendments to their unemployment statutes, others are in the works. The Department of Labor also significantly expanded both its rulemaking and the publications that it issues around the various employment law challenges of remote work. Remote work really came into the forefront over the last couple of years. And even though many of the underlying laws that really set the standards for best practices in remote work didn't necessarily change fundamentally, many of the risks that attend remote work may have really come to the forefront for you and your business, because where many employers in the past had few, if any, remote workers, now a substantial portion of the American workforce works remotely either all or some of the time. And so, these new and upcoming laws and a new friction of litigation around remote work, around the unemployment system, they could promise a potential sea change in wage and hour litigation over these concepts like termination, voluntary quit, even family and medical leave. Finally, employers should always be aware of the wage and hour liability related to remote work. Again, even though the fundamentals of these liabilities may not have changed substantially, the massive sea change in favor of remote work in the workforce may have brought some of these once esoteric and obscure liabilities really to the forefront of your compliance program.
All right, and thank you for that overview, Christopher. Last but certainly not least, we have attorney Jessica Youngs, who will deliver guidance on the changes to equal employment opportunity taking place in 2022. Jessica Youngs, the founding and principal attorney at Octans Legal, is an international attorney with over 15 years of experience in law. Jessica's practice focuses on general counsel services for small and mid-sized software, technology, and commercial clients, and includes employment law, corporate data protection, and risk management consulting. She is barred in the states of New York, Illinois, Georgia, and the District of Columbia.
Thank you for that introduction, Leon. And like Chris and Jeff both said, I'm very happy to be joining Personnel Concepts for another webinar. Today, I'm going to be speaking with you about disability and discrimination. And on the federal level, same as what Jeff and Christopher said, our main focus here is COVID. And for that, we're speaking specifically about long COVID. Long COVID has now been recognized by the Department of Health and Human Services and the Civil Rights Division of the Department of Justice as being a disability. So now that it is recognized as a disability, it of course falls under the Title II and Title III of the Americans with Disabilities Act. It falls under Section 504 of the Rehab Act and Section 1557 of the Patient Protection and Affordable Care Act. And with that, what our most concern is really, what is long COVID? Long COVID is something that is lasting for weeks or for months after a COVID infection and can include things like continued tiredness or fatigue, difficulty thinking or concentrating, chest pain, respiratory issues. And now that it is officially recognized as a disability, we see that it can be a disability in two ways. One is as a physical or mental impairment. So for example, long COVID can be a physiological condition that affects a body system. So for example, lung damage, heart damage, or it can substantially limit one or more major life activities. And we have some guidance here from the Department of Justice. An example of that would be someone who is experiencing memory lapses or brain fog could be substantially limited in their brain function, their concentration, or their thinking. So with that in mind, we are saying that long COVID is considered a disability, and because of that, we want to make sure that employers are aware that it must be treated as a disability and cannot be discriminated against if there's a request for reasonable accommodation made under the ADA or one of these other related acts. Also on the federal level, we have coming up the Equality Act. The Equality Act was passed by the House in February of 2021. It's currently before the Senate and awaiting approval. We probably will see that approved or at least something substantially similar to its current iteration. The Equality Act amends the Civil Rights Act of 1964 to officially include sexual orientation and gender identity as protected classes. So it adds 2 new protected classes to the ones that employers are already going to be familiar with, such as sex, age, those sort of things. Now, this is already kind of set out since the 2015 Supreme Court ruling that it is considered a protected class under that gender category, but this would officially amend the law to make it so that it is officially recognized there. And it also has some implications with the Religious Freedom Act, which are important to consider. On the state level, we've had some movement in terms of discrimination. California, for example, passed the Silence No More Act, which prohibits non-disclosure provisions in settlement agreements, and where those settlement agreements specifically involve workplace harassment or discrimination. It does not have to just be sexual harassment or discrimination. It can be any of those protected classes. In Georgia, we're seeing this month, or at least in the new term, state senators are going to be considering a new bill to have some uniformity within the state. We're seeing in Georgia, as well as some other states, that local municipalities or counties are making their own rules as they relate to discrimination and passing their own regulations there. What we're seeing in Georgia, as well as some other states, is an attempt to unify those so that there's not a differing patchwork of anti-discrimination laws. In Illinois, we've had an interesting thing come up where disability discrimination is now considered a discrimination against an individual. So, for example, discrimination against a disability, be it autism, be it long COVID, whatever it may be, a certain type of disability, that is now considered disability again, or discrimination specifically against an individual who may have that disability. Montana, we've seen movement that kind of follows what we've seen in other states, California, for example, where discrimination for off-duty marijuana use is now prohibited. However, in Montana, it only goes so far in that there's no private right of action that's been created if there is, in fact, a termination or a discipline based on off-duty marijuana use. We do anticipate that that is something that's going to come up in more and more states this year and in future years. So certainly keep an eye on that if you are in one of the states that does allow medical or recreational marijuana use. In New York, domestic workers have been specifically included in the New York human rights law to prohibit discrimination against domestic workers. And then we've seen some movement in North Carolina, for example, and in Oregon. These are places where they're following what's been happening the last few years in other states that relate to discrimination based on personal appearance, specifically based on more natural types of hairstyles or way of dressing. So for example, in Oregon, the anti-discrimination statute has been amended to be more inclusive of locks, braids, those sort of things. And this is sort of a continuation of what we've seen in other states, and certainly something that we will see continue, I think, this year and in the future years in many more states to come.
Thanks so much for reviewing that all with us, Jessica. Before we begin, Personnel Concepts is offering all of our attendees the New Year, New Laws report for federal and California customers, along with today's slide presentation equipped for note-taking, all of which are attached as handouts right here in GoToWebinar. At the end of the session, you'll receive an email certificate as proof of your attendance today. To participate in today's Q&A session, I want to encourage everyone in attendance to submit questions by using that Ask Question feature here in GoToWebinar. I see that some people have already utilized it. That's great. You can also contact our webinar staff by using the chat window. If you'd like to pose your question directly to the guest speaker using computer or telephone audio, audio, use the raise hand feature in GoToWebinar, and we'll coordinate with you on your request. We'll do our best to get through the most relevant audience questions throughout today's 45-minute Q&A session, and then all unanswered questions will be submitted to our attorney panel for responses and sent to you via email. So with that, we need your help with one more poll before we get started with the questions and answer session. Leon?
Yes, as you've heard, our panel of experts are prepared to answer your questions on workplace safety, wage and hour, and equal employment opportunities, especially as they relate to COVID-19 and the new laws being enforced in 2022. Now, outside of the selected topics, we'd like to know what employment law topics might you need addressed in today's Q&A session. We'll do our best to oblige. Do you have questions about A, interviewing and hiring? Is it B, workplace policy assistance? Is it C, record keeping and documentation? D, labor law posters and notices. That's definitely our expertise here at Personnel Concepts, in addition to HR laws and general consultation and help for businesses. And then E here, or are you a federal contractor or in a specific industry, you need assistance with your compliance efforts there. So we'll just give everyone just a few moments to go ahead and answer those, and the answers are rolling in quick. We want to get as much time as we can for today's official Q&A session. So I'll go ahead and share those results with you. I'll make sure to bring those results down. I know they're up for just a little bit long last time. We did have 59% of people that said they may need some assistance with record keeping and documentation. So all of our panel experts, please keep that in mind as you answer our questions today. And also about 38% split at interviewing and hiring, workplace policy assistance, and just barely trailing behind at 34% labor law posters and notices. So kind of around the board, people want to know what's going on in their 2022 employment law agenda. So please continue to submit those questions in the question window, and I'll do my best to get them answered by our panel of experts.
All right,
And
so I think we're ready to start our Q&A session. I think we can put our first question on the board. Is that correct, Leon?
yeah, and this is one that was asked many times, submitted by registrants, and also we're getting some questions just now. And so it seems like a good place to start. Stephanie, go ahead, take it away.
Sounds good. Okay, so our first question is, can you provide an update on the federal vaccine or test mandate and specifics for compliance? So I think I'll start, direct this one to Jeff first, and if anybody else has anything to add, feel free.
Thank you, Stephanie. I'm happy to answer it. Where we are basically is where we talked about a little bit in the presentation. Maybe a few people are coming in now. What happened was the federal government, through the Biden administration, was planning on putting in an emergency temporary standard through OSHA to all businesses generally. So all businesses, private sector across the country, would have had a standard requiring them, as of the beginning of this year, to require vaccines or test. And the vaccines are required to be substantial compliance with the vaccines. So as we know in the country, we have now 3 shots, all of them the same, Pfizer, Moderna, and Johnson & Johnson, and 3 rounds of those shots. Basically the same as I understand it. Moderna and Pfizer certainly are the 1 and the 2 and the booster. The booster is another version of the shot. Substantial compliance has generally meant 2 of those shots. In certain local jurisdictions, being on the road to doing it with 1 is permitted, but generally speaking, 2 is required at this point. The booster is uncertain in terms of the regulatory matrix, but the businesses were required generally under the ETS standard, because we were in a state of emergency, which gave OSHA that authority to have their employees, if they had more than 100, become vaccinated. They were to document that, and they were to know about it. What happened was challenges emerged very quickly. Other challenges to what we've seen so far, which were the religion and disability-based challenges, more broad challenges emerged across various parts of the country. And based on what courts they went to and what the politics of those areas were, and generally speaking, if they weren't of the same politics as the federal government, generally speaking, they tended to be ones where the court challenges got more heft more quickly and were given more credibility, because there is a certain scraping that goes on between the different parties based on who's in charge. So certain areas of the country that have those types of political makeups, there was more resistance there. I've been recommending to my clients and the employers generally, and I do work with people in different sectors, some industrial, some warehousing, some more traditionally referred to as professional services type professions, to follow the vaccine mandate. It is for the health and safety of the workplace. It is likely to pass through at least some of the courts and be upheld. And it is the best practice at this point, even if you can find a way to wiggle around it. You'll be following the news clips daily, trying to figure out exactly what you should do. There are places where injunctions are in place, but overall, I would say follow it. As far as the testing alternative, there are persons in the workforce who have a disability-based reason, or perhaps a religious-based reason, or one of the other accommodation type reasons we've heard about, who cannot or will not get the vaccine. People in those circumstances are required to submit to testing. That is the way that the employer can have information that generally assures them that they are safe if they are not vaccinated. I'm not 100% sure on what type of testing. We can follow back up on that, whether the PCRs or the rapids are the requirement. I do know that generally speaking, and I know this can be an expense for employers, if you're able to outfit your employees with PCRs or link yourself up with a medical company that's doing that. I know I work in New Jersey primarily. I know in New Jersey there was a brief window of time where the Department of Health was allowing people to apply for free PCRs, and me and many of my family and friends applied for one. You went through a link on the State Department of Health's website, kept one at home. The PCRs are more reliable, as I understand it, than the rapids, and so you'll get better data from those. Of course, they do take a little bit longer to get a response. So basically, compliance overview. Follow the mandate that we talked about today that's in place. Follow it in my recommendation, and as much as I can make one, regardless of whether you can find a wiggle around in the jurisdiction you're in, because it hasn't gone all the way up to the Supreme Court anywhere and hasn't been completely ruled on, and the federal government is still trying to impose it. And they're doing that with the idea of trying to keep the national health in line. I realize this can pose challenges for workplaces, but it will be a best practice, and it will put you in the most safe and healthful situation you could be in.
Thanks, Jeff. And if I could just chime in on one wage and hour piece to be mindful of, that I think it hasn't necessarily gotten the same kind of attention as, you know, the fundamental political questions about the mandate itself, is there is a wage and hour component to the vaccine mandate insofar as OSHA standards require employers to give up to 4 hours of paid working time in order to get vaccinated. And from the perspective of your record keeping and documentation, that is working time, right? So if an employee on your staff needs to take time to go get vaccinated, and the nearest facility where they can do so, or the best available appointment is, it's far away, it's inconvenient, you need to give them up to 4 hours. And those 4 hours, like I said, are for ordinary working hours, meaning that they, for example, contribute towards calculating overtime. They go towards calculating, whether or not somebody's going to be eligible for hitting volume targets on their hourlies, that kind of thing. From the perspective of a recommendation, I'm not being a medical professional, I don't want to step too far afield here, but I know that many states and the federal government have programs in place that you can have vaccine sites set up on workplace premises. You could have doctors either come visit your workplace or set up nearby and make that request through state or federal government. And you as an employer are not required to give the maximum amount of time off to go get vaccinated, right? And in fact, if you have people in your workforce who you think will need your assistance getting to a vaccine site, the most convenient, cost-effective way of doing so might be to avail yourself of some of these programs to have vaccine and testing experts and professionals either appear on your work site, or if you work in a large complex, that might be easier to accomplish. So try to avail yourself of these programs, but do be mindful of the fact that the mandate does in fact require that those 4 hours be treated as ordinary compensable working time if an employee needs the working time off to get the vaccine.
Very well put. Thank you so much, both Christopher and Jeff, for your input on that. I think we have another question on the board here, so I'll just move along. The question is, many people are claiming a religious exemption, but most religions do not have a vaccine exemption. What should we do in this situation? I think I can direct this one maybe towards Jeff, if you're up for answering.
Yeah, I'm happy to, and maybe someone else will step in with a little bit of anti-discrimination. I've actually seen a lot of these with my clients, and I guess if you're a constitutional law scholar, which maybe some of us up here are, and probably the workplace folks, maybe they don't want to do that. It can be a little bit of it makes your head spin. But the thing about this is, it's not so much the religious exemption is kind of a commonplace term we're all using, and this is important, a distinction that's worth sharing with those that are listening. The religious exemption roots in our First Amendment, which everybody's sort of familiar with it. You know, free speech, freedom of religion, freedom of gathering and association, political freedom, things of that nature. But it's not really a religious exemption exactly. It's tied to the religious exemption in the Constitution, but it's really any sincerely held belief. So if you get on the other end of one of those situations, you poor folks in HR, or what I've been doing helping my clients, you're going to start to see some interesting things that are kind of come your way about what it is people think in terms of what they believe in connection with the vaccine. There isn't going to be no more are we constitutional scholars perhaps than theologians and trying to figure out exactly where in the great books of yesterday this vaccine situation of 2021 is provided for. It's like I said, it's a little bit of a head spinning exercise. It's crazy making, but basically if anyone presents to you an argument that they have a sincerely held belief that for some reason the vaccine is offensive to their sincerely held belief, and it may or may not include the tenets of an organized religion that you're familiar with, you are obligated under the exemption to assess that and to give them the alternatives, the accommodations, which would be perhaps in the typical workplace, working more distant from their coworkers. Masking certainly is one that's available for those people that still have the remote work functionality inside of their workplace, maybe giving them the chance to stay working remotely. But I understand the question is there are no religions that say anything about vaccines. I can't comment on that as a lawyer or as a pretend theologian. I don't know for sure, but I've seen the arguments made. And it's more based upon a person having a sincerely held belief. And if they believe that the vaccine is somehow offensive to their personal beliefs and they can put an argument together, that's probably good enough to give them the exemption. There are some people out there that are working very hard to do that, and I understand that it can make HR people a little incredulous. Where are they coming up with this? But don't overthink it. If their belief is pretty well put together, and also another thing from a legal perspective, if it looks like it's pretty well put together, there's a very good chance that they might be trying to create a situation that could be bad for the employer. Sometimes they could be sort of setting themselves up for a lawsuit. So if it looks like it's pretty well put together and well argued, even if it's hard to maybe find a place in literature where or teachings where it makes sense. If it's well argued, it only needs to be a sincerely held belief, and it could even be the sincerely held belief that they simply don't believe in vaccines. That's enough. I know that's complex, but it's the best way to go is if they have a well put together argument, try to give them an accommodation. And certainly you don't have to share their accommodation with other people in the workforce outside of your control group. So if it is something that's concerning to you, keep it isolated so more employees don't follow suit and follow the same, form a small religious group there at your workplace with all believing in anti-vaccination. Try to keep it on the down low and just deal with it and accommodate it. And certainly if they're religious based or belief based, they shouldn't want to share that, and you don't have to share it on their behalf. So that'll allow you to sort of isolate the problem, silo it, and move on, I think.
Very well put. Thanks so much, Jeff. Hopefully that answered your question there to our audience. Let's see if we have another question on the board here. There we are. If an unvaccinated employee is required to test weekly, but the test results are pending before she has to report for work, does the employer count that as paid time off?
That's an interesting question. I'll jump in on that. So the OSHA rule that was published already does not specifically address the pendency of test results as far as I know. As far as I know, the requirement is that employees submit to testing. There are a couple of different questions about the paid time off portion of this, because there is the time required for actual testing, which can be minimal, virtually nothing, because you are allowed as an employer to administer or not administer, but to have administered the COVID test on site if you prefer it that way. I don't know if that's the best way to go from an epidemiological point of view, but you are allowed to do so. Now, there is some description in the OSHA rule for paid time off in other circumstances. circumstances. For example, if an employee is suffering side effects from the vaccine, many of us who've been vaccinated remember, soreness, aches, tiredness, that kind of thing. These should be treated as ordinary, illness conditions, and there is text in the rule that relates to recovery from side effects of the vaccine, but it doesn't have the same kind of strict 4-hour time off requirement that the vaccine does, for example. So the best practice for right now is to administer these rapid response tests. I think that it's the PCR test. Whenever I get the test of CVS now, I don't even have the option for longer term results. It's just the one you sit in your car, you get your results 10 minutes later, and you're off. Because I don't think that employers should be subjecting themselves to this question of what do I do with an employee who is now waiting for their test results? Are they being treated as on call, which is a compensable situation in other contexts? Are they not? Is this just fallow time while waiting for results? The best practice is to use the rapid results test. You can get your results in 10 or 15 minutes.
Great. Thank you so much for answering that, Christopher. All right, let's see what we have up next on the question board here. If an employee has been diagnosed with long COVID, what would be an appropriate, reasonable accommodation time frame for someone who is suffering from this issue? I'm going to give you this one to Jessica here because she mentioned long COVID earlier in the presentation.
Yes, great. So my turn for a question. So long COVID, we do have it that it's been recognized by the ADA. Some of the things that are recognized under the ADA as a disability, some of the things that could be done for reasonable accommodations are things like providing additional time to complete a task if there are concentration issues, or modifying a procedure for someone who may find it difficult to stand or to do physical work. So for example, someone who is normally walking about quite a bit, as long as the essential job function does not require that, they could do that more easily from a sitting position or from home if they're having respiratory issues. Of course, working from home is many times going to be a reasonable accommodation. We are also seeing some suggestions about, for example, individuals who are having respiratory issues, perhaps moving their way of communicating from voice or phone conversations, these Zoom conversations that we've all been so familiar with, to more of a texting or email setting, if that's something that can be done so as to not tax their ability to breathe while speaking. As well, we're seeing reasonable accommodations come in the form of, again, many of these are related to standing or sitting or talking, just because that's the nature of the illness. So for example, accommodations to allow people to be sitting more often. We're also seeing some accommodations for people who have hearing issues that have come up from COVID. I know, hard to believe, but it has happened, to, again, maybe moving it to a more isolated working environment, or a working environment where they're able to use headphones or something of that sort. So we want to treat this in the same way that we would treat any other request for an accommodation under the ADA or the Rehab Act, and that's to look for ways that we can work with the employee to allow them to still complete the essential job functions. Of course, that's critical, right? They do still need to be able to complete those essential job functions, but allow them to do it in a way that is a bit more flexible. And I think since now many of us are working from home, we are getting more used to modifying how we're working and being more flexible in searching for an accommodation there.
Great, thank you so much for that insight, Jessica. All right, let's see what question we have up next on the board here. With shortages on tests for COVID, how should employers handle this? And who would like to jump in on that?
I mean, I'll try it. Maybe someone else could add some color as well. Happy to. If you have shortages on tests where you are, it's a tough question to tell you what to do if you feel like you need to test at the workplace but you don't have tests. I would say that through our lectures here at Personnel Concepts and through the long duration of this COVID pandemic, there were other times, if we can think back historically, to when we didn't have vaccines, and perhaps to some extent we didn't have such a wide amount of tests. If we can use what's in our toolbox from the other experiences we've had, then we would go back to a time, for instance, where we thought about recognizing the symptoms and asking the employees to self-check with the symptoms for COVID. Now, I know we know the symptoms vary with the various variants, I guess, but there are different symptoms, but they are all similarly related. Again, it was good. I appreciate Christopher catching me there. I'm not an epidemiologist either, but there are different symptoms. We know that Omicron, I think generally speaking, a lot of people speak about a sore throat. The earlier version of COVID, a lot of people had fevers. There are other tools you can have in the workplace that you can still use that the CDC earlier in earlier lectures through Personnel Concepts talked about, like doing temperature checks, doing self-diagnoses in the morning to see if you have any of the symptoms. If you can't get tests and everybody's got to go to work, then check the latest CDC guidance for what the symptoms are and advise your employees to self-check and to perhaps record that information when they come in. That's going to be your best other alternative, because it's probably not going to be conceivable to tell everyone to stay home while you wait for the tests. There are agencies at the state and federal level that are trying to push tests out there. They're trying to do that, I think, because it's good and helpful, but I think also it's allowing them to track data. That seems to be the impression I'm getting, because the tests that are coming through the state are very specific, and the steps people have to follow and how they have to report and things of that nature. But you'll look for those resources as well, as Christopher mentioned before, but also look back to what you have in your memories from how you dealt with COVID as a workplace and use some of those other previous tools. Go back to the extreme sanitization, the hand washing, all of those things that should be going on anyway, but try to enforce all of those, as well as the self checks and the temperature checks and things of that nature.
I would just add only one other piece to that, and best point is well taken about essentially do your best, right? But also, since many members of the audience have questions about their record keeping obligations, on this specific question, the closest thing that OSHA has actually given us to guidance basically just says that they're going to look at your patterns and practices for good faith attempts to comply with the rule, and this is not published to any sort of level of regulatory certainty. It's essentially an FAQ document that OSHA put out addressing this question. And so basically what that means is that if you are trying to comply with the test mandate and you're simply unable to do so because the tests are not available to you, just keep good records of the attempts that you've made to comply. You've reached out to municipal, state, federal authorities for more tests. You called CVS. You had somebody at your office looking for ways that they can get tests to the office. Just keep records of these kinds of things, because as Jeff said, we don't have regulatory certainty on this question. The best that we can advise is to do your best to get access to the tests, and don't assume that if there is a drought of tests in your neighborhood, that means that you're off the hook for compliance.
All right, thank you so much, both of you, for your input on that. Hopefully that helps them, guides them in the right direction. All right, let's see what question we have next on the board here. If you are a border state with a state that has passed medical marijuana and your state has not, would it be discrimination in hiring to disqualify an applicant from that state that claims to be prescribed medical marijuana? So discrimination. So I don't know if Jessica, you want to take this? I know Christopher, you also have a background in that as well. So.
Yeah, sure, I can handle it. And I also would like to say one thing about the question that was asked earlier. I realized they didn't necessarily respond to that directly, and the question was, how long does long COVID accommodation have to last? And the answer is, you're going to treat it the same way that you would any other disability. So it lasts for, the accommodation is going to have to last for as long as the symptoms and the impairment of functioning is there. So that is sort of the answer. I would, though, explore to see whether there is maybe some FMLA or emergency leave that can be used as well in conjunction, or maybe even first. On to this specific question, well, you're in the state that you're in, right? That would be my answer. Christopher may have another response there, but certainly what happens at your workplace, if you are physically there at the workplace, then you need to follow what your state rules are. So if medical marijuana use is not legal in the state where you, an employer, are based, then certainly you have the right to set policies that say that marijuana use is not going to be tolerated within your workforce. I think that's the short answer. We certainly could get into more whether or not your state is going to be moving the way towards medical marijuana use, but it certainly would be helpful to have a policy on this, I think, for all employers as to drug use at the workplace. If Christopher has anything else to add, I know this is one of your specialty areas.
Sure. I think as was mentioned in the intro, I do a fair amount of work in regulatory compliance in the adult use cannabis industry. But Jessica's point is well taken. You are responsible for obeying the laws of the state that you live in. And there are many places in America where you can cross over a state border and be subject to a completely different set of cannabis-related medical laws, recreational laws. I mean, I practice in the New England area. I believe Jeff does as well. So, there are many places in the country where basically every other state has a medical marijuana statute, right? But the long and short of it is, as Jessica said, if you work in a state where there is no medical marijuana, or even in states that have medical marijuana statutes, many of those states actually have carve-outs in their state statutes that it remains legal to discriminate against users of medical marijuana. That's largely in order to comply with federal law. There are often provisions in federal work contracts and GSA contracts that are inconsistent with state cannabis laws. So, this can really vary from state to state. And even within states where cannabis is legal, for example, in Massachusetts, where I largely practice, even though the state statute has such a carve-out, there is already language from the courts in Massachusetts saying that in some circumstances you might be able to reasonably accommodate a medical marijuana user. Obviously, the courts do very rarely give us clear guidance about how that actually works. But the long and short of it is the rules are sufficiently confusing that you should talk to experts like Jessica if the situation comes up in your workplace, because the rules are going to be highly, highly dependent on your state's own statutes. It is not a binary legal or illegal, even within states where, a quick Google search will say, yes, there is medical marijuana in Massachusetts. There's always more to the story than that. And I would always advise somebody to talk to a disability and accommodation specialist, and not to speak off the cuff here, but I would do so before talking to a marijuana specialist, honestly, because members of the cannabis side of the Bar Association are often going to be as go as they can about accommodating people in the workplace, and the disability specialists and even advocates like Jessica are going to have a much clearer read on what your obligations are going to be in the workplace.
All right, thanks, Christopher, and thanks, Jessica, and thanks again for doubling back on that last question. We're going to move on to the next question. Let's see if we can do a little rapid fire because we only have about 10 minutes left here, so I want to try to get through as many as possible. The next question here is, CDC shortened the quarantine and isolation guidelines. Can my company enforce a longer isolation period than the CDC recommends? Jeff, you want to take this one on?
Yes, yes, and I'd like to take it on. Yes, the answer is yes. It's basically related to a connection to the health and the safety of the workplace. We don't know from the question who exactly you are, but for no uncertainty, everybody out there today probably has different types of workplace environments. Some that are more close quarters, some that are perhaps more physical, some that have a great freedom of space, an open floor plan, and things are good for those people and they have lots of places they can go. If you feel like your workplace, for the health and the safety of the workplace, for operational needs, requires you to have your employees stay out longer than the recommended guidelines, that is acceptable. I would set it as we recommend here with the Personnel Concepts lectures that we all do. anything related to affecting workers' rights or anything that could be looked at as discriminatory or imbalanced, always set a policy and make the policy applicable to all. So all would be applicable to the same policy. So it's all right to have them stay home longer, but just make sure that you put it into writing, communicate it to your workers, and make sure that it affects all workers, because obviously there's going to be people who are going to want to come back. Perhaps they're going to want to come back for personal reasons or sooner or whatnot. And if you don't have a policy in place, they're going to raise challenges, and those challenges could morph very quickly into, because people would be in a difficult situation if they wanted to come back to work to make income, and perhaps they couldn't, or they had to use up their vacation days and they didn't want to. So make sure that the policy is applicable to all, so that no one in one situation or another feels discriminated against or makes allegations of discrimination. But yes, for the health and the safety of the workplace, with good grounds and a good basis, you can enforce a longer stay out time. That's a private right that inures to the employer.
Perfect. Thanks, Jeff, for that guidance there. All right, the next question we have here, given the increased awareness of systematic racism and the rights of the LGBTQ plus community, do you recommend diversity and inclusion training for all employees? Jessica, I think this one's for you.
Yes, and this is actually a topic that I did an entire webinar for Personnel Concepts on last year, I think, or at least quite recently. So certainly do check that out. We specifically talk about sensitivity training and diversity training really quickly, because we're running out of time, and there's one more thing I know that we need to add right now. But it is, yes, of course, please do diversity training, please do sensitivity training. There was let's see, in 2020, I guess, there was the executive order that came out that blocked diversity training for federal contractors for a short period, but certainly do it. As an employer, you have potential liability if your workplaces are toxic, if your workplaces are making insensitive jokes or racial slurs that people may not even realize are insensitive or that may culturally impact one group of people that are in your workforce. So it does not do any harm, and in fact, it does a lot of good. Please do include diversity and sensitivity training, and check out the webinar that we did previously. And then I know I just messaged Stephanie, because we in fact do have right in time for the end of the webinar, we have the Supreme Court's decision on the COVID mandates that just came out a few minutes ago. So very quickly, the Supreme Court has in fact gone ahead and blocked the federal government's vaccine or test requirement for the large workforces. So workplaces of 100 or more employees, that mandate has been blocked. There was, I think, a three-person dissent, three-justice dissent on that one, but it was blocked. And then on the other mandate that we were looking at, which is for workers at federally funded healthcare facilities, that has been allowed. And we did have a four-justice dissent, but that mandate has gone ahead. So that's kind of your breaking news for the moment. Some of the other panelists may have something more to add on that, since they're more the COVID experts than I am.
Yeah, and just before they chime in, yeah, we did get a question about it, actually, what you can see on the screen now. I had to make sure I can confirm it before I put it out there and put you guys on the spot to answering about this recent ruling. But yes, Jeff or Christopher, if you could chime in on what you think this means for employers, specifically, obviously, those with 100 and plus employees.
Sure. I guess I'll chime in first. You know, as always, it's great to see Personnel Concepts breaking the news before anybody else. So thank you for that. Obviously, not having had time to review the actual ruling, my advice is as follows. Number one, be aware of the fact that this ruling is addressed on the procedural question of, does OSHA have the right to impose this mandate, right? So what that means is that the Biden administration may try other avenues to impose a similar mandate. So I would not, hang up your compliance protocols just yet. Number two, many states have also imposed their own requirements that are analogous to the mandate that OSHA had put out. So again, I would be very careful to take a look at your state's vaccine requirements, see where they may be similar or different from the OSHA mandate, and just, I I am very skeptical that this will be the end of the Biden administration's efforts to get some kind of a private employer vaccine mandate in place. But I welcome Jessica and Jeff's thoughts on that point as well.
I just want to add, I just want to say that I agree with everything everybody said. I also got the breaking news alert, and it's frightened me because so much of what I said in the beginning was in the pre-Supreme Court ruling context. But to Christopher's point, there are many levels of regulation, and I also stand by the recommendation that the best practice is to continue to follow the general spirit of the vaccine and testing mandate. It will lead to a safer workplace. It is being pushed by many entities at many levels, down to local municipal governments. In my travels in New England, as we alluded to, I've seen some cities up here that have very strict rules in the city itself. New York, which is also near to where we are, has incredibly strict rules for both workplaces and also places where the public go, restaurants and things of that nature. And if you can believe it, at certain places, we don't see as much of this in America, but even right up to the border, I just found out a few days ago in Canada, there's a province that actually is not even allowing inside dining in the entire province. So they're right next to us here in the Northeast. They're our neighbor. The best practices for health and safety would still be to try to follow the spirit, I believe. And you will likely see, most likely, to Christopher's point, probably in response to the Supreme Court ruling, you may even see some states and local governments now stepping up and stepping quicker. They're a little bit more nimble as governmental entities to sort of make things happen. And the health and safety aspect of this does fall within traditional state powers. So you may live in a state where, in response to the Supreme Court's decision, the local government or the state government or the county government, depending on where you are, steps in and enforces or creates their own similar policy that maybe they didn't have to do that before, but they'll be doing it now, probably in response. So there'll be more breaking news, I think, in the days ahead, and I recommend trying to check a reliable source to find out what the status is where you are.
All right. Thank you all. And thank you, Jessica, for bringing that up. What perfect timing. Thanks, Christopher and Jeff, for your additions there. Unfortunately, we've run out of time. All of the unanswered questions will be forwarded to Jeffrey, Christopher, and Jessica via email, and the responses will be sent to all attendees in the coming days. Thanks so much to everyone who submitted questions for today's session, and thanks to our panel for taking the time to answer them.
Yes, thank you so much. And like she said, we have unfortunately ran out of time. I do want to just encourage everyone to continue to submit your questions now. We're a little bit long-winded with some of the questions because they're very good. So we want to make sure we got you adequate answers. Then obviously we just had that breaking news, which took away some time from the questions you guys submitted. But if you continue to submit your questions now, we will email the responses back out to everyone in attendance and everyone that registered. So please continue to use that question window, and we'll do our best to get your answers in the next couple days. Before we get out of here, though, we do just want to have one last poll. I did see already in the question window, people are very approving of this type of session in this format. So we want to just get a little bit of feedback about how you participated today. So we want to know, A, did you submit a question and have your question answered? B, did you submit a question but didn't receive a response? Like I said, there were a number of responses. We will get back to you via email. C, you didn't submit a question because it was already answered. Is it D, I didn't have any employment law related questions? Or is it E, you just attended to hear questions from other attendees, as we had many great questions today. So thank you guys all that participated. It's much needed. We're going to end with a few takeaways before we wrap up the session, and I'll just share what you guys submitted. So 52% of you said you attended to hear questions from others. 30 didn't submit questions. So it looks like the 18% of you that did submit a question didn't have it received. We'll definitely get back to you. Only 4% actually had their questions answered. It's a little bit embarrassing, I'm not going to lie. We were hoping to get through some more, but I promise we will get to you guys on the back end. And hopefully there's just a few people that didn't say that they got their answer or their question answered, because we definitely answered a number of questions today. But we'll go ahead and move on. Jeffrey, if you could start our descent here and give us your key takeaways from the 2022 workplace safety issues, obviously considering the new news that we just got.
Sure thing, Leon. And thanks to everybody today who attended, and also to Stephanie and Leon for organizing, and my co-panelists. It was a big pleasure. The latest guidance tells us that the Supreme Court has decided the 100+ mandate for vaccines and testing is currently been overruled. However, we recommend that you check your local rules to see what applies to your workplace, as something may very well still be in place for vaccines and testing. And there are other federal agencies in the days ahead and other federal maneuvers that we anticipate will come to fruition. But right now, in this time, check for what's going on locally by you. Additionally, monitor the Centers for Disease Control and their website for updates as COVID-19 response guidance is revised. And finally, work the best you can to implement policies throughout your workplace that are non-discriminatory in all matters related to COVID, and how you treat the employees in regard to any policies you set.
Thanks so much, Jeff. Christopher, can you remind us of the key wage and hour takeaways?
Sure, thanks. And as always, and as Jeff said, a major factor in this is that mid-seminar we've had a substantial change to the rules, but I am already receiving notifications about states that have stepped up now that the once preemptive OSHA rule has been cleared out of the way. Their own rules may be in the works. So just keep an eye on that, obviously, as we go forward. But whether or not there is a vaccine mandate, the one big thing to remember is that as we go forward, there's a whole separate slew of wage and hour related liabilities that attend remote work. And this is going to be the case regardless of there being a vaccine mandate in place or not, right? Many workforces have just migrated online, so these are important things to keep in mind. I also want to quickly remind everybody about these substantial changes to the unemployment statutes, both at the federal level in terms of the duration, the amounts, and the reasons for getting unemployment, and your responsibilities relevant to administer that system. And there are other state laws that either have been implemented or maybe in the works in your state that extend extra protections to employees who, quote unquote, voluntarily quit in the face of a vaccine mandate. Sort of hard to see how exactly that's going to play out if there is no more vaccine mandate. But I'm happy to follow up on that with the written Q&A that you guys submit afterward. And finally, to just be mindful of any new or continuing updates on the obligations that you may have as an employer related to remote work. As always, be mindful of DOL's publications, EEOC publications, and new guidance that may come out in response to the migration of many workforces to a remote work location.
All right, much appreciated, Chris. And Jessica, please bring us home with the key EEO issues for employers to consider.
My pleasure. Well, nothing has changed on the discrimination front with the new Supreme Court ruling, so we are still good to go on all of this. First thing to keep in mind, long COVID, familiarize yourselves with what the symptoms are, with what some of the things that your employees may be facing who have had COVID. It does run the gambit across a pretty big spectrum of issues that may arise after one has had COVID. So do familiarize yourself with what that is. If you need to, take the time to look at your reasonable accommodation policies. This may be the first time you've ever had a reasonable accommodation request. So do take a look at those. And of course, the Department of Labor, Department of Justice, they do have some good guidelines on what potential accommodations could be. The next thing is keep an eye on the Equality Act, that we should see movement on that this year. I think if you are a religious organization or a charitable organization, do keep in mind that this may have significant impact on your business or your operations. So you should also make sure to familiarize yourselves with that if it is passed or if it's of interest to you. And then finally, continue to monitor what's going on in your state, but especially on the municipal and on the local levels We are seeing municipalities be more active, especially in anti-discrimination laws that are coming up. For example, the more natural hairstyles, medical marijuana, or recreational marijuana even for off-duty use, all of those kind of things we anticipate that we will continue to see more and more movement on this year and in coming years.
Okay, thanks so much, Jessica, for reviewing that for us. Before we end today's session, I'd just like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance to today's webinar. We really enjoy hosting webinars for our valued customers, and as such, would really appreciate your feedback. Please stick around a couple of minutes as a brief survey will open for you to rate what you saw and heard today.
And this does conclude today's webinar. Thank you for attending our presentation. We hope you enjoyed and benefited from today's 2022 Employment Law Update Ask the Attorneys webinar session. Thank you to Jeffrey, Christopher, and Jessica for participating as our expert panelists. We look forward to continuing to working with them on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand by using the link provided on the screen. Also, please subscribe to our Personal Concepts podcast, The Labor Law Report, for bi-weekly employment law updates hosted by myself and Stephanie. You can actually use the QR code at the top corner of your screen. And we will be sure to update you all on the recent ruling from Supreme Court. We did our best on postponing today's webinar till after the ruling. They actually discussed their arguments on the 7th. We're hoping that we could give you the latest news, and we were able to do that today, so we're happy with that. But hopefully you did get something out of today's webinar presentation. There was plenty of useful information, and we'll make sure to send it out to you shortly after today's session. Now, to all our attendees, thank you for choosing Personal Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.